last 2 years on the regulatory side, and they kind of come fast and furious. And the most recent me here, I'm Badour. I'm a partner in the Financial Services Group at McCarthy. I co-lead our fintech practice. I'm also a certified anti-money laundering specialist and a certified Bitcoin specialist. So tend to work on the financial services side with the regulatory aspects of innovation and new technologies. The regulation that exists out there in Canada really has to date attempted to be both principles-based and technology-neutral. But that being said, we certainly see, as people try out new business models or new platforms, that they sometimes encounter some issues in terms of the regulatory aspects or their need to modernize in certain areas. And so we've seen a lot of developments that have occurred, especially in the last 2 years on the regulatory side. And they kind of come fast and furious, and the most recent one for those of you who are banks or deal with banks is a new federal financial consumer protection code that was introduced about 2 weeks ago. It was a long time coming. It really originates from a Supreme Court decision about 2 years ago that required banks to essentially comply both with federal and provincial law and led to a modernization of the federal financial consumer protection requirements. Puts a lot more teeth with the regulator, so certainly seeing that as going to be an area of focus for banks. Also, there's references in there, even though it talks about a consumer protection framework, to person, which from a legal perspective could mean commercial entities or commercial transactions. So really expect to see a lot more focus on the compliance side for banks on the lending compliance with respect to things like sales practices. So those of you may have seen in the news last year, there was a lot of controversy with sales practices at certain banks. Some of the changes really result from things like that. Additional disclosure requirements, including possibly in respect of commercial loans. And generally, more focus on the fact that there might be regulatory enforcement coming. Other kind of hot button areas, high-cost lender regulation. That's at the provincial level, and a number of provinces have passed or are considering additional regulation of high-cost lender, which they define generally as 32% or more as an interest rate, requiring registration in those provinces, and essentially, putting those lenders that lend at that level under the jurisdiction of certain provincial regulators. Those are kind of two kind of big items that we're seeing, but there's essentially a lot of different areas that lending touches upon, everything from securities to privacy, as well as the consumer protection side. And so really want to throw it out to the room. I want to hear questions that people may have. It's always a lot more interesting when we hear what you're dealing with. Also have a colleague in the room in the back as well, Simon Fitzpatrick, in our structured finance group, and we tend to work together quite a bit. And Simon works more on the structuring side, so we work with platforms quite a bit, where I would look at the regulatory and he would kind of shape out how we should look from a structuring perspective and the transaction itself. So I might turn it to Simon depending on some of the questions. Go ahead, David.
Okay, this is not a softball. She was sitting there. And if Toronto has the #2 financial services center in North America, has the #2 technology center in North America, why do we have the #23 fintech ecosystem? What are we doing wrong? How do we fix that?
Well, I mean, some of it is regulatory and some of it is not. So I'll focus on the regulatory side. It's challenging in Canada because of the mix of provincial and federal jurisdiction. So federal jurisdiction is over banks and the business of banking, essentially, as well as things that are systemic, like payment systems that are systemically important. And there's also essentially things like privacy legislation on the federal side. But then a lot of what's happening in fintech is actually provincially regulated. So lending, for the most part, unless done by banks, is provincially regulated. Securities, until now, provincially regulated. That being said, there was recent approval of the federal federal securities regulator initiative, which is essentially kind of a passporting kind of harmonization as opposed to moving it out of the federal jurisdiction. That really means that anything regulatory on the fintech side typically involves 13 different players who may have very different views on what things should look like. And so it's very challenging from a coordination perspective, and from just seeing the process on the federal securities regulator process, which took, I believe, about 10 years or so. You can see the struggles. So that's one of the challenges. Another challenge is, frankly, it's the flip side of what we've done well. Canada came out of the financial crisis looking great, and we were very much praised for our regulatory system, which was more conservative than some others, more principles-based, and more really focused on stability. And so regulators didn't have that pressure to modernize and change that you might have seen, especially in the US or the UK. And that's really what directly led to the open banking innovation, because from a regulatory perspective in the UK, financial crisis led to the financial regulator having more of a competition mandate, which then led to open banking. And so Canada doesn't have that history, because we actually were very much praised coming out of that. So there wasn't that political impetus to change the way that some other jurisdictions have. Obviously, there's a lot of other reasons that aren't regulatory, but those are some of the regulatory drivers. Okay. Yeah.
Consumer or commercial or both?
Consumer lending.
Is that the commercial side or research?
Not at this point, but we do see more and more focus on whether sole proprietors or consumers. And that we see especially that in Quebec, their definition of consumer is broader. In other provinces, generally, it hasn't been, other than quirky things like fishermen and farmers, which for some reason are treated as consumers. But kind of looking globally around the world, the theme of are sole proprietors and small business more akin to consumers than not is one that we see kind of come up repeatedly more and more. So, at the end of the day, regulation is in reaction to market practices. If markets are behaving well and treating, parties well, then generally there's no regulatory reaction. But to the extent that there starts to be practice of perhaps bad behavior in the small business market, small business lending market, you may see an expansion of what is a consumer, or maybe some new kind of regime that is in between consumer lending and what we have right now.
Other questions?
Sure. Yeah. Oh, go ahead.
So when you do regulatory reviews, whether it's small business or consumer facing companies, whether it's for lenders like us or originators themselves, what are the most common mistakes that you see companies making?
Great question. So it is all over the place. We see some of the patterns that we see are on the compliance side. So things like sanctions compliance tends to almost always not be up to snuff when we do reviews. And so every entity needs to comply with sanctions laws, and where people may not realize is anti-money laundering laws only apply to certain types of entities. There's a criminal code that applies to everyone, but the need to have a whole anti-money laundering compliance regime only applies to prescribed entities. And sanctions laws, on the other hand, apply to everybody. So we see some small business lenders, for example, not screening the names of their borrowers against sanctions lists, which is something that over time may get them in trouble, because you need to be onside sanctions laws at all times, whether or not you have a positive screening obligation. Another area that we see come up quite a bit is inter-stack disclosure, either in terms of the criminal rate. So there's a criminal rate requirement where you need to keep, otherwise known as usury laws. You need to keep your interest rate below 60% in Canada. That's in accordance with actual calculations. And we see sometimes where the 60% is not properly calculated. It may look on paper to be under 60%, but when you dig behind, it may not be. There's also a requirement to disclose an interest rate, in and of itself. And I've seen that come up as an issue where there's no rate disclosed anywhere, and under the Interest Act, if you don't disclose your interest rate, 5% interest rate applies. So obviously that's not something that you want to be offside of. and just disclosure requirements in general. And they can be very detailed, especially for things like payday loans. Extremely regulated environment. We actually find payday lenders are usually quite clean because they've been so closely monitored by the regulators that they're on side. But there are very complex requirements that change quite a bit. In the case of payday loans, they're almost constantly changing and being updated. So hard to keep up with those requirements. And then the cost of borrowing disclosure requirements, where you have to disclose things in a very precise, prescribed way. And Quebec in particular tends to be a challenge. There are things like, there are certain types, essentially you have to disclose credit charges, which is a term used in Quebec, and some of the items that would constitute credit charges, you can't actually calculate them on an annualized manner. So sometimes we've seen people actually have to pull back certain fees that they're charging because they can't disclose it properly under Quebec law. And that was the source of that class action that I mentioned that led to that federal code, because banks themselves were having a hard time complying with that requirement, and that's where they had an issue. So cost of borrowing is extremely complicated and very technical, and Quebec is particularly technical. And so we definitely, almost always see a Quebec issue when we review documentation. Other questions? You had a follow-up question.
Just on e-documentation, X to Y extension, e-wallet acceptable under the PTSA, both on the consumer side and commercial side, it's less acceptable, but on the consumer side, people will execute out, execute myself using DocuSign and whatnot.
So we have electronic commerce legislation in every province that essentially says that you can use an electronic signature other than for certain prescribed types of agreements, which are things like wills, sometimes transfers in real estate, so that's where you usually sometimes an issue from the lending side. It's province by province. So conceptually, electronic signatures are okay. Where it gets technical is whether or not the way that it's implemented complies with the legislation, because you need to essentially have a way of authenticating that the right person signed it. So you actually need to drill down and see, does this technology do it in a way that corresponds with the legislation? So essentially when we're asked for advice, we have to get a whole essentially description of the process from start to end to see whether or not it tracks it in a way that will comply. So conceptually okay on the whole, but you need to actually look at the precise solution that someone is using in order to confirm whether or not it actually complies.